This lecture focuses on constitutional law as it relates to sport, including freedom of speech, religion, press, and assembly, the First Amendment, and unreasonable search and seizure, which is covered under the Fourth Amendment. Constitutional law only applies to state or public actors. This means individuals or organizations that fulfill a government function are considered a state or public actor. For example, Minnesota State University Mankato is a state actor. The Veterans Affairs Hospital is another state actor. Both are public state entities that perform something on behalf of the government. The Mankato Moondogs, in comparison, are a private actor. So constitutional rights would be protected in the VA hospital and at MNSU, but not necessarily with the Mankato Moondogs. There are some private organizations that have been considered state actors in the past. These organizations also perform some government functions. So via what's called public function theory, a private organization takes over government responsibilities, or nexus entanglement theory, when a state actor and private organization are very embedded with each other, it could be considered a state actor. So for example, state high school leagues have been considered state actors, public actors, even though they are often private organizations, but they perform a function in running all of the high school sports, which includes a lot of public high schools in various states. In terms of athlete individual rights in professional leagues in the United States, teams have often been considered private, but they have collective bargaining agreements, which are contract negotiations, and a contract and players' unions that negotiate these contracts between the players, the teams, and the league. So antitrust laws allow this. And essentially what ends up happening is that things like random drug testing, which could violate some rights depending on what context you're in, are negotiated into these contracts. So the collective bargaining agreement changes how constitutional law is applied in professional team sports in terms of player rights. There are two primary clauses to know related to the First Amendment and freedom of religion. The first is the Establishment Clause, and this states essentially that a state actor can't endorse a specific religion. And then the Free Exercise Clause prohibits the government from getting in the way of people practicing their religion. So people are allowed to practice freely without governmental interference. Here's a quick way to think about what's legal and not legal in terms of prayer in public schools. So legal prayer is non-sectarian, meaning it doesn't endorse a specific religion. Legal prayer in public schools is student initiated. So it's truly that students want to pray together, pray separately, pray individually, whatever, but they initiate it. What is illegal is classroom prayer, because generally there is a teacher or staff member present and students can feel pressured to engage in that prayer, or administration initiated. So something that a staff member, a teacher, a principal initiates that endorses a specific religion is considered illegal. There are a few tests that the court uses to help figure out if prayer violated the First Amendment, starting with the Lemon Test. So the Lemon Test looks at three things. It needs to examine the prayer and determine if the prayer is secular or not. So if it is general, it doesn't endorse a specific religion, then the next step is, does it endorse or advance, promote, or suppress a specific religion? And does it avoid excessive entanglement with religion? If it passes these three things, it did not violate the First Amendment. The other two tests to determine if prayer violated the First Amendment in a public setting are the coercion test and the endorsement test. So the coercion test examines or attempts to determine if a person felt pressured to participate in a prayer. So for example, your coach decides to lead prayer before a training session, the first one. Players are unsure kind of what to do. They don't want to upset the coach, so then they participate in the prayer even though they didn't necessarily want to. The endorsement test attempts to determine if the government promotes one religion over another. If it does, it violates the Establishment Clause. In terms of freedom of expression, the First Amendment holds the Free Speech Clause. This is the right to say what we want without government interference. There are some limits on that, however. Commercial speech is partially protected because the government is trying to prevent false and misleading ads. So companies aren't supposed to be lying about stuff, and if they do, the government might step in. And people are also not protected. Their speech is not protected if it defames someone's character or threatens another person. The Fourth Amendment covers unreasonable search and seizure. This protects people from governmental entities like public schools, public universities, or police from searching or taking property without probable cause. The applicability to sport is in the area of drug testing. In terms of figuring out what's reasonable, the Supreme Court has kind of put forward two questions to consider. The first is, was the search justifiable at the start? Was there a reasonable suspicion to start searching someone's locker for drugs in a school? And the second is, was the scope of the search reasonable? So it looks at the degree of intrusion versus the person's privacy. There are three primary arguments as to why the government would be interested in drug testing in sport. The first is that drug testing will provide a more fair competition because it will eliminate the few people that may be taking performance-enhancing drugs and get everybody back on a level playing field. The second is that it would make the competition safer for athletes. So athletes would, if they're, know they're going to be drug tested, the argument goes, they would stop trying to use drugs that could be harmful to their bodies or their minds. And then third, that it would deter drug use. If you don't know when you're going to get tested, how frequently, then athletes would theoretically be more likely to not use performance-enhancing drugs because they're not sure when they're going to get tested and they don't want to fail and be eliminated from their competition. The court often uses a balancing test to determine if the state actor violated the Fourth Amendment. This weighs the privacy interest of the individual versus the government's need for testing. Okay. Privacy issues from a student perspective would be, if a student athlete, if you're getting drug tested at a public school, is that a urine test is embarrassing. You have to leave the door open, someone stands there and watches you go to the bathroom, you hand it back to them. So could be a little embarrassing. The test may also reveal other health issues that could come up, which leads to privacy issues. And then it regulates off-field conduct, which some would argue the school is only supposed to be dealing with what's happening in the school, and regulating off-field conduct is out of the scope of what a school should be involved in. That should be up to the parents. A key case related to drug testing in public schools is Vernonia versus Acton. In that, the court ruled that drug testing is permissible in public schools because student athletes have lower expectations of privacy. The court argued that student-athlete use of locker rooms where you change and shower near others essentially lowers their privacy expectations, therefore the school could drug test them at random. Again, constitutional rights are only protected from interference by state actors. So working at a public hospital, public school, a university, or attending a university or a public school, your rights are protected. The First Amendment covers freedom of speech, religion, and assembly, while the Fourth Amendment protects people from unreasonable search and seizure, and drug testing falls under that Fourth Amendment category.